Good afternoon. This is Peter Towers from ESS BIZTOOLS. Welcome to this webinar on the Personal Property Securities Act. There's people still registering, but we will get started in a moment. So thank you very much for coming to this webinar today. If you have any questions, can you please type your question into the system? And in webinar terminology, raise your hand and I will answer the questions to the best of my ability towards the end of the webinar. So let's get started. The Personal Property Securities Register is causing some concern around the country, and I believe it's something that accountants should be looking at very seriously. Millions of dollars have already been lost by businesses, both small and large, that have been caused by ignorance of the Personal Property Securities Act and by not registering on the Personal Property Securities Register. So that's a big problem that has started to occur. What does this mean to accountants? And importantly, what role do accountants have in assisting their small, medium enterprise clients to understand the legislation, which some people have claimed is the most far-reaching business legislation introduced into Australia in the last 200 years. That's a big statement, but it's worth looking at and understanding what is happening under this legislation. Title is no longer king. The biggest change has been that the fact that a business paid for an asset does not mean that business is able to retrieve the asset at any time, unless the business has taken steps to adequately protect their position on the Personal Property Securities Register. By way of illustration, there was an article in the Sydney Morning Herald on the 26th of July, which was headlined, $50 million win for forged creditors if challenge to APR succeeds. The reporter indicated that 4 gas turbines worth about $50 million had been leased to Forge. Forge subsequently had a liquidator appointed by a secured creditor. The secured creditor liquidator did a search of the assets that were on the property and found that these 4 gas turbines had not been registered on the Personal Property Securities Register. So the liquidator is now applying to the New South Wales Supreme Court for a ruling as to whether the liquidator, on behalf of the secured creditor, is able to secure those assets and dispose of them as the liquidator sees fit. It will be interesting what the judgment of the court is in that case. Personal property, it's a bit confusing in any case, just the terminology. A lot of people have said to me, well, if it's personal property, what's the fuss? My personal property is my golf clubs and my record collection, etc. Someone said to me, well, unfortunately, the wording might not be clear, but it covers all forms of property other than real estate. And it definitely does cover business property and business assets. What we've done within the Personal Properties Securities Register due diligence review that we have developed at ESS BIZTOOLS is step-by-step procedures to guide an accountant, an advisor through the process of giving advice to a client. We've incorporated videos and articles and checklists and various forms to assist in this process. Within the package, there are 3 separate papers on various aspects. The most detailed one is 051005, which is a complete overview of the Personal Property Securities Register system, written for a small medium enterprise audience and accountants, which fully analyses the whole process. The other papers that are listed there are looking at some of the operational issues, and the last one on this one here on how an accountant advisor might go about implementing a system to assist their client. Within the system, we have developed a number of forms, and I'm going to go to those now so that you can get an understanding of how it works. We have a form which we're prepared to assist you to have a discussion with your clients about frequently asked questions on the Personal Property Securities Register. First question, very common one. I'm in business, so how is the property personal? Do you have to register your interest in property you already own? Well, you don't have to do it. I think this is one of the confusing points about this whole legislation. It is voluntary. And the word voluntary has led some business people to think that they really don't have to worry about it. Well, unfortunately, most business people will have to worry about this legislation. And the real trap is it might never affect some of your clients, or it might not affect someone for many years' time. Because for there to be a problem, there has to be an insolvency event. A liquidator, receiver, or trustee in bankruptcy has to be appointed. And hopefully that will never happen. But if you have clients who are operating in general business activities, then this could occur at some time. Another form I'm just bringing up to show you now is what are the 10 PPSA myths. Some people think that it's going to cost thousands of dollars to gain protection. In fact, going back to the Sydney Morning Herald article on Forge, the reporter has commented that the business that owned those gas turbines could have registered their interest on the Personal Property Securities Register for an outlay of $16. $16 to protect $50 million worth of assets. In fact, I'm not sure where they got the $16 from. I would have thought it was $8, but it costs $8 to get a registration for a 7-year period. It's a very low insurance type cost, if you like to put it in those terms, to be able to protect business assets. So that's just giving you an overview of the type of forms that we have listed there. What I just want to bring up now to show you is the major control form, which we call a procedure control form. This guides an accountant through. You would first of all record your client's name and industry and contact person, and the procedure form is then able to be used to first of all prepare your quotation and proposal, and there are some articles there that the system automatically links to, those papers I looked at a little earlier with you. There's a form there to assist in preparing the quotation to undertake this work for the client. So there is the form that would assist in preparing the quotation. We've gone through and dissected all of the work components to undertake a due diligence review of a client system. You can place in your time estimates to how long you think that is going to take to analyse those various processes with your client. And you can see there's some questions getting asked as to where property is stored. We're going to come on to that in a moment because that's one of the big issues in this legislation. And there's issues raised there in item C of licenses, trademarks, intellectual properties, loans, statutory fishing rights. They're a strange one, but they're in there. Assets held in trust by other people, service entity arrangements with other entities. Now, these are all included under this legislation. There's been a legal case in Queensland which cost the owners $2 million worth of plant and equipment. They had entered into a typical service company arrangements. How many of these have you got with your clients where the asset owning business had leased the equipment to a trading entity? The trading entity had obviously borrowed money from a secured creditor. The business got into the trading entity got into financial difficulties. A liquidator was appointed. The liquidator checked the register on the PPSR and found that over $2 million worth of Caterpillar equipment, tractors, bulldozers, etc., had not been listed. The liquidator proceeded to register that in his name as liquidator for that business. He then went to the Supreme Court in Queensland and sought their approval for seizing those assets, and the court supported that action. The problem was that the asset owning entity had not registered their interest in those assets on the Personal Property Securities Register. How many of your clients have you got who have got similar type of situations that perhaps you need to revisit? It can also cover loans. Same situation where there's a loan to a closely associated entity, and it's going to get paid some stage, hopefully, and a liquidator happens to get appointed, and the liquidator, if it's not registered, would be within his rights not to recognise the legitimacy of that loan. So if we go back to the procedure control form now, it continues to work its way through on a work plan timetable. There is a proposal document there that you can use to send your proposal to the client. And there are documents to assist the client to understand what you're doing, and I've already shown you a couple of those. The frequently asked questions, the 10 PPSA myths. So at that stage we might move on to the next slides, and we'll come back to that procedure control form in a short while. We also have a link to the video that's been produced by the PPSR, which is a video for small business that if you haven't viewed, I would sincerely suggest that you do so. And to assist you in doing that, we've included that link to that video. So where to start? There's no doubt that your clients require commercial legal advice. They require advice on a retention of title clause which should be drafted after January 2012, but preferably, obviously, if it's going to get drafted now, it would be in August 2014. The key point is that it incorporates the requirements of this legislation. and a terms of trade agreement needs to be drafted. Some of your clients might need more than one terms of trade agreement. They could have different type of trading arrangements with different customers, that if their original terms of trade agreement was not broad enough, they would need to have more than one agreement. And obviously within their customer base, they might have more than one situation. However, the drafting of the retention of title clause and the terms of trade agreement are only the beginning of this process. Unfortunately, many people believe that this is the end of the process. It is not. The Personal Property Securities Act is very complicated, and in my opinion, the responsibility then passes to accountants and advisors to ensure that an appropriate system is introduced within the business to safeguard the business's assets. So the big question is, do your clients have a system? Even though they've been to see solicitors to have the documents drafted, I don't know too many solicitors. In fact, I've racked my brain of the hundreds of solicitors that I've dealt with over my career, and I cannot imagine too many of them physically going to the client's premises and going through and doing a detailed due diligence review of how the client's business systems operates, so that all the variations that we're going to show you shortly that apply under this legislation can be appropriately noted and procedures introduced to protect your client. When the GST was introduced, the Liberal government of the time spent millions of dollars in educating businesses, both large and small, on how the GST would operate. Unfortunately, neither the previous Labor government nor the present Liberal government have seen fit to finance a major education campaign for businesses, especially small businesses, on the operations of the Personal Property Securities Act. There was little chance of the GST sending businesses broke, but it's a real possibility that it could be the fate of a business for not complying with the requirements of the Personal Property Securities Act. This is the real problem. As the trusted advisor, which accountants I think correctly believe that generally we are, shouldn't you be assisting your client, even if it's a risk management strategy, very similar to an insurance policy, to avoid the potential business failures that can occur under this legislation? So what transactions are caught? Some people believe the only time they have to worry about this legislation is when they sell their businesses, to ensure that any items that have been registered on the Personal Property Securities Register by other people over the years have been withdrawn. If only this were true. There's a whole range of actions that need to be taken by most businesses to ensure the business is able to survive intact, and well before they consider selling their business. So let's look at some of the transactions that are caught under this legislation. Goods sold with retention of title clause, commonly known as REMALPA, as long as those clauses have been drafted after January 2012, can give some real protection for businesses that are making supplies using those retention of title clauses. Supply of goods on consignment. You must have a number of clients who are supplying goods on consignment. They can get some protection, but they just cannot walk in and repossess their goods on consignment in the event of an insolvency event unless they have registered those assets on the Personal Property Securities Register. And there's been a couple of cases that have proven that. Goods stored in someone else's possession. There's been 8 legal cases in Australia so far on this legislation, and approximately 50% have been on a dispute that involves goods or property being rented, leased or stored. Obviously in all cases the actual property is on someone else's premises or real estate. And this can be a real trap. Goods attached to other goods. Now this is one of the few areas, in my humble opinion, that there's a benefit for some businesses under this legislation, because we have this concept of a cession. And a cession is where someone, for example, a steel fabricator has made a set of steps that are going to go to a mine that are going to be attached to other property that's already at that mine. Traditionally, those sorts of transactions did not have a remalpa clause attached to them, because it was going to be impossible to go and repossess that particular asset if the supplier was not paid for it. But that's now all changed. No one can go and repossess unless a registration has been made on the register. In the case of goods attached to other goods, this terminology, a cession's been introduced into the legislation, and those businesses can get some protection by registering their interest on the register, and as always, in case a insolvency event has occurred. So it's an area to look at for a lot of your trade type supply businesses. Mixed goods, where ingredients are supplied to a bakehouse, for argument's sake, or a pastry cook, and there's flour, there's sugar, there's milk, there's fruit particles, all being supplied by different suppliers. This legislation allows that to be followed through. Motor vehicles are definitely included. Equipment renters. Sources are telling me that equipment renters have been fairly heavily hit by this legislation because they ignored various components of the requirements and haven't registered their interests. Motor vehicle leases, rental and lease of plant and equipment, debtors, especially if the debtors have been assigned to a factoring organisation. Livestock on adjustment. Some graziers are panicking, but obviously they have got property which is on someone else's site. They need to have a registration made on the register if they wish to fully protect themselves. Farmers' crops have got some special clauses in the legislation for the benefits. Tradesmen's plant and tools of equipment. There's been some legal skirmishes over formwork and other building plant and equipment on building sites. Feed for livestock is also a special area that's been introduced into this legislation for some protection. So the type of transactions that are caught include seeds, fertilizer, pest control, all for crops. So that can be, if you're a supplier, you've got a client that's supplying those sorts of articles, they can get protection. Artwork and sculptures normally are supplied on a consignment basis, can be protected. Loans, licenses, assets held on trust. So you've given some property or assets to another organisation or another person to hold in trust for you. You need to consider whether your client should be protecting their interests. Service entity arrangements, I've referred to those. Intellectual property, where a company's developed the intellectual property and then entered into an agreement with a second company to market and sell that intellectual property, but they have full possession of it. You'd be well advised to get some legal advice as to whether that activity should be registered on the register. Rental and lease of premises can cause problems because obviously if you're the tenant, you're going to place a significant amount of plant and equipment, stock, computers, all sorts of things into what is in effect someone else's property. If that landlord goes into liquidation, there can be some problems. When the government introduced this legislation, they obviously assumed that every business person would study the legislation and understand how it worked, and would lodge the required legislation to protect their interests. In theory, that sounds fine. However, in practice, the amalgamation of 60 Acts of Parliament from the Commonwealth, state and territory governments around Australia has caused a lot of confusion. This can only be overcome through a methodical approach to conducting an individual due diligence review for each client within your practice. So some of the items which we have looked at, and I'm going to bring this form one which we call BAS, doesn't mean anything to do with the tax office. It's Business Advisory Services, and it's our form 1645. These are some of the areas that have got to be looked at very closely: stock, livestock, goods, artist works, plant and equipment, whether it's owned or on lease, etc. So we'll just go to the form, and I'll bring form We've drafted this form to assist an accountant in undertaking a review of their clients to analyse what's going on in the client's business. And this is the sort of work that I don't envisage their commercial solicitors going to do for them. Incidentally, how many of your clients can nominate to you who their commercial solicitor is? In my experience, when I ask small business operators who is their solicitor, I get a funny look on their face, and I get replies like, well, I had a driving problem 10 years ago and I had a guy get me out of trouble on that, or I got divorced 12 years ago. What we're looking for is who is their current commercial solicitor. I suspect that more than 80% of small business operators don't really have one. So who are they going to turn to get this advice? And that's why I'm recommending that you should be assisting them to do this by encouraging them to go to their solicitor to get the agreements drawn up in the first instance, and then assisting them on the implementation of appropriate systems. Some commentators are claiming that only 5% of small businesses are aware of the problems that this legislation could cause them. My observation from running these types of webinars over the last 6 months is that many accountants are also not aware of the consequences of this legislation. So let's look at it. In stock, there's some various definitions. Now, anything that's on your own premises that you own is probably okay. But once you get into lease premises, I'll just get the highlighter there. Once you get into lease premises, someone else's premises, or just on consignment, there are potential problems that you might need to closely examine and have a conversation with your client as to what would be the consequences if they don't register and an insolvency event occurred for wherever those stock items were placed. So we then go on with some questions about that. Then we look at livestock and crops. I mentioned before that livestock on adjustment is a potential problem. So obviously it's on someone else's property. You've got livestock. Oh, we've put livestock on adjustment quite separately. My team asked me why we've done that. Livestock and adjustment is a big issue for a lot of graziers, and I know this is causing a lot of concern amongst the grazing fraternity, so we listed it as a separate item. We've also listed thoroughbred horses, primarily because there's a lot of concern in Australia about the treatment of thoroughbred horses, because there's been a major legal case in New Zealand, and incidentally this legislation is based on some New Zealand legislation that started in 2002. And they've had their fair share of court cases on the interpretation also. Over there, a racehorse had been leased for stud purposes to a farm business, and lease payments were being paid. They stopped making the lease payments. The horse was actually repossessed by the owners, but a liquidator was appointed. He knew about the horse. He went to the New Zealand courts and got support that he could reclaim that horse, and he could sell the horse for the benefit of the secured creditors. because the owners had not registered that thoroughbred horse, which the reports say was worth $2 million, had not been registered on the New Zealand equivalent of the register. You would not have a very happy day the day you found out about that if you were the owner, would you? And how would you feel if you were the accountant or advisor to that particular business? There are also particular protections there for crops. Then we've got other goods, goods left in someone else's possession, goods sold on your behalf by someone else, goods attached to other goods, that's that accession that I'm talking about before, mixed goods, and so it goes on. Artist works, where are they? Plant and equipment that you own, if you rented some to customers, where is it located? And then we get into leases. Now leases are an interesting area. You can lease items that have not got a serial number on them, and serial numbers are normally defined in this legislation as being applicable to motor vehicles, aircraft and watercraft, boats. But for an article that hasn't got a serial number on it, you can lease it for up to a year and you have no problems. If you've got a lease agreement that says it's leased for 11 months, you don't have to worry about any of the consequences of this legislation. But if it's leased for more than 1 year and you want to have it protected, you need to have registered, because that is deemed by the legislation to be a personal property security lease for a term of more than 12 months. And the other term that comes into play is if it's leased for up to 1 year and automatically renewable, so it might just say for 12 months, but it's automatically renewable. Again, that is deemed to be a personal property securities lease. And if you want protection for it, you need to register. But the real trap is an indefinite period is deemed to be something that falls under the definition of a personal property securities lease. And to get protection for a personal property securities lease, you need to have registered on the register. Now, what's an indefinite period? I must admit I had to go and check a few dictionaries. But it's obviously can be something that you've entered into an arrangement to lease or rent something for someone for 4 or 5 days or 6 months. That it's just ongoing. It's not specified as a time. I probably said that the wrong way, so let me re-say it. It might be an indefinite period that's only lasted 4 or 5 days or lasted 6 months. And if that is deemed to be something that could be covered under a personal property securities lease, therefore, if a liquidator, etc., is appointed, they can seize that asset. And this has been one area in the building industry in particular that's been causing quite a number of problems. Our forms then go into motor vehicles, and I just want to show you one other component of this. In a motor vehicle situation, though, the law is different. It talks about 90 days. So a lease of up to 90 days, you've basically got no problems with. The same thing applies, though, for this indefinite period. And then the 90 days or over or 90 days automatically renewable, both for all these 3 items, indefinite period, 90 days automatically renewable, and more than 90 days, all fall into the definition of being a personal property securities lease. And if you want protection, they need to be registered on the PPSR. So the purpose of this form, obviously, that we're going through is to alert you to this, to start looking at the assets. So we then go into boats and do the same thing on boats and other watercraft. We're then going into aircraft. Obviously, you have clients that won't have all these sort of assets. And then we're looking at other personal property. What else do they own? But remember that word personal is really business. And we've identified some of those items then, debtors. financing arrangements, licenses and trademarks, that you've done deals with other people that they can have the use and possession of them. Should they be registered? Now, there's no doubt that when you go through and do this due diligence review, you may have some questions that you throw up that really need to be referred back to the client's commercial solicitor. That's okay. But when the client first talked to the solicitor, they might have forgotten about some of these issues. How many of your clients can really sit down and explain how their service company arrangements really work? And do they remember whether there's proper documents being drawn up? Most of my clients over the years didn't remember those sorts of things. Intellectual property, what's going on there? And so that form goes on. So hopefully that will give you an idea of how all that is working. And what we're now going to do is go back to our slides, and there's the rest of the headings that I've just been showing you in that BAS form 164.5. So our suggestion in developing a customized system for your individual clients, and virtually every client's going to be different here, because hopefully I've already identified to you there's all different assets floating around that businesses in exactly the same industry could have a completely different outcome once you've undertaken a due diligence review. In each case, though, our recommendation is that you utilize the system to create a procedure control form for each of your clients. You download it into your hard drive and away you go. And then every client's going to need consideration of retention in the title agreement and terms of trade. And then you need to move on. So we have then developed this concept of saying, and I just want to go back to the forms. I said to you earlier, registration on this register is voluntary. Therefore, we've developed a document to assist the client to nominate the amount of money that they might be financially embarrassed about if they never recovered that from their customers, or the value of an asset that if it was placed on someone else's property, that if a liquidator got appointed and they lost it, they might be financially embarrassed about. In the case that I read out to you from the Sydney Morning Herald, I would suspect that $50 million would be an embarrassment. Now, in some of your clients, $5,000 might be an embarrassment amount. Others, it might be $50,000. Others could be $100,000. Just bear in mind that bad luck normally runs in threes, so you might have a bit of a run on some of your clients' customers at some stages. But we've developed a form which is trying to assist in the identification of what the debt might be that they need to be covering. And then there needs to be an analysis of who the customer is. Now, we're not suggesting that you need to take out cover in effect on federal government, state governments, or even most local government organisations. There will be some public companies that you say, well, we think they're safe. However, though, public companies also go broke, as the article I read from the Sydney Morning Herald was relating to a public company. But then once you get down into small public companies and other proprietary companies and some charities, I'd suggest that serious consideration needs to be given to making a registration if the exposure to that customer is likely to exceed the financial tolerance figure that the client has established. And then we have a form which we're calling 1651, which enables all this to be tracked through. So they've established it for the business, then what's going to be done relative to the financing statement, etc. So what needs to be done is that the terms of trade agreement is sent to the customer. The customer has to sign and return the terms of trade agreement, and then a document referred to as a financing statement has to be prepared and placed on the register. Now, there are some very strict time requirements for this to happen. If you're supplying, your client's supplying inventory items, stock, to a business that's going to sell them, then that registration needs to be made before the sales are made, the product is delivered. Now, I emphasize you don't have to register every transaction, but it's preferable from the time that you start trading, or your client starts trading with someone or starts this process, that you are then, in effect, got some sort of protection. If you've sold a tractor to someone, you have got 15 days from that date for that transaction to be registered. And if it's some other type of transaction like a loan or a intellectual property type transaction, you've got 20 days. Now, when all that's done on those timelines, your client will then be able to register what's called a purchase money security interest, a PMSI, which is about as good as the security you're going to be able to get to be able to recover your client's money, as long as there's any money in that business, of course. That is a security which will trump most others. They can still get some benefit if they register outside those time limits, but they will not get a PMSI, which is really what they should be trying to get. They will receive back a verification statement from the PPSR that's automatically sent back to them, and they need to send a copy of that verification statement back to their customer, unless the customer is contracted out of receiving that. And there needs to be a system then put in place to monitor this registration, because it's going to expire in 7 years' time. And if they're still trading with that customer, they probably want to roll it over so that they've still got an ongoing protection. So someone needs to be looking at these particular requirements. So there's specific documentation there for the items that I've got on the screen there at present. We have developed then particular due diligence requirements for particular businesses. So a retailer, some of the issues that might apply are summarised there. They're selling goods to customers. They might be supplying goods on a consignment basis to another business. They might be storing goods and equipment in someone else's premises. So we'll just have a look at that form. We've developed similar types of forms for this for about 16 different industries. So this is going through looking at it from a retailer's point of view. There's some questions to be answered as to where the stock is, what they've done, have they talked to their commercial solicitor, have they got some documentation prepared. That will just give you that little bit of extra material to conduct this due diligence review for an individual client. Sorry, we got ahead of ourselves there. And what I meant to go back and just show you, we have developed individual control sheets for 16 industries. Some of those industries are listed there so you can see them, which are all part of the system. Equipment renters, ingredient suppliers, even down to thoroughbred horses. So they're all covered. Under the legislation, there's been a number of court cases already decided in Australia. In each case, the liquidator or receiver acting for a secured creditor has won the case against the business that actually paid for the asset. So the business that paid for the asset has lost in each of the court cases in Australia, and there's been 8 of them, because basically the business has not registered their interest on the Personal Property Securities Register. I'm told from by people in New Zealand that basically the same thing has happened in New Zealand. In each case, the liquidator has won, because in most situations the businesses have not registered their interest. We conducted one of these webinars a couple of weeks ago with Smith Inc., with David Smith, and a participant was a liquidator. He sent us the following, I'm trying to show you the full. He sent us a testimonial because he spoke at the webinar and said what he's saying there. Unfortunately, business owners generally find out the hard way when faced with an insolvency practitioner who tells them that they no longer have title or ownership of goods. Can you really envisage having that conversation with one of your clients? And Darren Vardy went on to say there is certainly an opportunity for all accountants to add further value to their relationship with their clients by conducting a Personal Property Securities Act review to ensure their compliance. We think these reviews should be done now and then followed up every 6 to 12 months with your client. So the product that we've given you an overview on today, we're calling our PPSR due diligence review. It is part of the ESS BIZTOOLS Gold package. So if you're a Gold subscriber, or you're interested in becoming one, everything we've shown you today is part of that package. That package costs $2,700 plus GST for 12 months 24/7 access per office, and covers a lot more information than just the PPSR. But we're also selling the PPSR as a separate standalone product, and the subscription for 12 months use of that material is $350 plus GST. If you're interested, you can go onto our website www.essbiztools.com.au and follow the links that are shown there to get access to the PPSR due diligence review to acquire them. We have some webinars coming up later this month. We are repeating this webinar today on Tuesday the 26th of August at 2 p.m. We're doing that primarily for Western Australia, South Australia and Northern Territory firms, so they can look at it a bit closer to their lunchtime. ESS Biz Grants, which is our other product. We've also in the last 2 weeks released a completely new version of ESS Biz Grants. It includes the new grants that the new Liberal government have released, and we have a webinar on it on Tuesday the 12th of August at 1 o'clock and Thursday the 28th of August at 2 p.m. So if you're interested in those. There will be a survey form sent to you as part of the process when this webinar is concluded. Within 48 hours we will send you a copy of the slides that we've used today, together with a link to YouTube where you can download a copy of this webinar for use within your firm if you wish. Now I'm now going to see if there's any questions. If you can't think of any questions now and you wish to ask us something else later on, please send us an email to peter@essbiztools.com.au and we will get a reply back to you. Okay, so thank you very much for participating in this webinar today. This is a very serious issue. Unfortunately, in some instances, it might be years before a problem is brought to anyone's attention, because obviously, hopefully, your client's not going to have one of their customers or a place where they've stored or rented assets at go into liquidation or administration. But unfortunately, it can happen, and it can cost a lot of money. So I do commend to you that you seriously look at introducing these types of due diligence reviews to your clients. Thank you very much for participating. Have a wonderful day.